students, welcome to the 107th session of Legal Empowerment through Interaction Lecture series. The journey continues of empowerment, getting exposed to different thoughts and ideas. Today, in the last 106 sessions, even though we are not pointedly looked into this topic at all, but still, we had at times debates over whether capital punishment should be there, shouldn't be there, and even those persons who are advocating for capital punishment, how to categorize some cases rarest among rare cases, and the dispute over giving benefit of doubt, reasonable doubt, residual doubt all came up during our discussions. And even in today's pre-session discussion and in our earlier discussions, we were even thinking that abolition of capital punishment could be counterproductive in the sense like mob violence or killings, and our new trend or the rising trend in encounter killings also may come in. But today we are having a complete relook of a very important aspect, and the master of the subject himself is here, and we are thankful and really indebted to you, Basant sir, for accepting our invitation and agreeing to come and address on this platform. We are also privileged by the presence of Justice P. Ramkumar, Justice Somaya Jalu, and Justice Sesharajam, and all of you.
I'm not Justice Sesharajam.
She's lawyer. She's lawyer.
I'm not Justice Sesharajam.
Your presence is, in fact, wonderful, so that we'll have better interactions and more interactions and different thoughts, etc., can come in definitely, ma'am. So
we believe in one day mortgage, always a mortgage.
Today I'm only a listener.
But the topic is so exciting, and I'm sure that you will be somehow or other lured into the discussion. Let us see, sir. And all of you wonderful participants, thank you for being here today. Let us directly go to Basant sir for the presentation.
Shyam, Ramkumar, Sesharajam, all the wonderful members of the group. I'm really happy that I have this opportunity to be with you. I've been watching with great interest the progress that this webinar series has been taking. Congratulations primarily to Shyam and this wonderful team which is doing this. I always envy Ramkumar that he's been able to maintain his academic sharp mind and attitude even long after his retirement. Wonderful to see him take part in all these interactions, academic interactions. Thank you very much for giving me this opportunity. Well, during the COVID times, I think most of us tend to take it easy. Not much of academics, not much of reading, people tend to relax during this period. But I'm very happy that Shyampadmanassociates they have introduced this webinar series, and I think it's catching up. I think all over you find a number of webinars going on, and I think, as I always keep saying, there is a fundamental chapter on fundamental duties under the Constitution. You're all aware of that, because very surprisingly to me, it did not come in when the original Constitution, we gave unto ourselves the original Constitution, but later on, long later in 77, during the period that they say the dark period of Indian constitutional and democratic history, this chapter finds its way into the Constitution, chapter 4A. It's just one article, that is 51A. And I always keep repeating, there's just one sub-article that I would like to think of on an occasion like this. That is Article 51AJ of the Constitution, which says, it shall be the fundamental duty of every Indian citizen to strive for excellence in all spheres of human activity, so that the nation rises to higher levels of endeavor and achievement. Poetic words, but I find that constitutional duty in action in these webinars that are taking place during this period, when we get some time to introspect, we have a relook at concepts which we think are so well settled and entrenched, and that is where the beauty of this experience, this enterprise lies. Congratulations to Shyampadmanassociates for having done this, and to all of you who are taking part in this program. Thank you very much that you have given me an opportunity to be part of it. But the webinars have increased like anything. But I think people are getting a little tired of webinars. You know, one friend told me when I said I'm going to a webinar, he said, today I also want to go for a webinar. I said, what is that webinar? He said, that is a webinar that tells you how to avoid webinars. So there has been a proliferation of this, and I think virtually every topic is being discussed. Good for us, especially for the beginners. I think it will be good that we get exposed to ideas. Very good. Thank you very much for having given me this opportunity. Now, the topic which Shyam gave me the option to choose, I was a little skeptical about the topic. What do I speak on? You know, I don't think on a topic like the ideal death penalty law for India. There is much of scope for discussion on the academic side. Perhaps there was a big question as to whether between the abolitionists and the retentionists as to whether the capital sentence ought to be retained on the statute book, whether that serves any penological purpose, whether that would violate the fundamental rights guaranteed under the Constitution, whether the dignity of life will be taken away by the state depriving citizens of their most fundamental of all the gifts of God or nature, as you may call it, whichever way you want to call it. And therefore, the question was whether there can be a constitutional in the constitutional scheme that we have a place for the death penalty. I think it was very much rife at a certain point of time, but I'm afraid today that topic is in not the ideal climate to discuss a topic like that, because you will find I'm a little surprised having spent a lot of time in the rule of law regime, when I find encounter deaths where persons in custody accused of very heinous crimes are shot dead on the road, shot dead after they are taken into custody. And that is one aspect. The other aspect is you find a lot of encouragement, appreciation of that sort of meting out justice. And that really worries me. And therefore, I thought it's not the time to discuss whether the death penalty should be there on the statute book or not. Well, maybe we are passing through a phase in our history, the legal constitutional history, where attempt to rake up that topic again might be counterproductive and may not be of much use. But that doesn't mean we cannot think. What does the death penalty serve? I'm interested. I'm not on the question whether death penalty ought to be there or not. My question is, what do we seek to achieve by retaining the death penalty on the statute book? Well, that's the most important thing. And then will come how best to implement that scheme in the scheme of things that we are thinking of. And therefore, if you all know, I need not go to the very fundamentals. What are the principles of punishment? What are the theories of punishment? Starting from deterrence, going over to retribution or reparation, reformation, all those there. But according to me, the death penalty serves only one purpose, and that purpose is the purpose of deterrence. I don't think it serves any other purpose. Subject, of course, you may immediately tell me that retribution is also served by the death penalty. But I think a civilized society, a modern society, a society wedded to rule of law, wedded to all the dignity of life concept, would not have readily accept that retribution is the justification for a death sentence. That's not the purpose. Well, because you want deterrence, you can't hang people as you please. There must be some justification, and therefore the doctrine of proportionality of response, the doctrine of retribution, etc., justify perhaps as to why we can choose to impose a death penalty on one particular individual. But I think essentially what is sought to be served is the concept of deterrence. Like-minded people who have a similar persuasion must be deterred from committing the offense, must be deterred from attempting to repeat such an offense. That evidently is the purpose which the a death sentence in modern society can serve? Deterrence, pure and simple deterrence. Now, I'm not taking you back to all those. There's a very important question as to whether deterrence is served. Well, are any more people deterred by the threat of death sentence than a mere life sentence? You know, that's a big question that has been. Those of you who have read Bachchan Singh, I'm sure all of you must have. Bachchan Singh, majority and the minority would immediately recall that the question as to whether the purpose of deterrence is served any better by a death sentence than a life sentence is a very important question, which we will have to consider. It is my humble opinion, after about half a century of experience with the system, that I cannot, with the empirical data, argue before you that the deterrence of death sentence is really productive. Well, I don't know whether I made myself clear. What is it? You can't ever get statistics. Can you get statistics for that? What are you looking for? How many murders have not been committed because there is the deterrent death sentence? That is the data that you have to. Empirical data that you can collect is only how many murders have not been committed because of the existence of the deterrent death sentence above the life sentence. No, that's the data that you want. And I'm sure you will never get data for that. It's impossible for us to collect data as to how many murders have not been committed because of the additional threat which a death sentence offers over and above a life sentence. I think it's very, very difficult. You go through Bachchan Singh, you go through any other treatises on the point, I don't think you can collect any empirical data. But you and I as ordinary individuals think that the threat to life is the greatest threat that a man can face, that a person can face. And if that be so, I think there is always a place of deterrence for the death sentence. A death sentence is what people detest, what people are worried about. Deprivation of the life on this planet is something which you are really worried about. Statistics may not be available. It is a very subjective assessment. And it is my assessment that definitely death sentence is more deterrent than a life sentence. I don't know how many of you would agree. The empirical data may not be available. I usually try to quote one example when I try to highlight this, because I think the Prime Minister of India was murdered by one of her own bodyguards. If that gentleman, fired by a sense of idealism or sacrifice, knew that his life was not in danger, probably he would have shot the Prime Minister down a couple of days earlier. I don't know how many of you would agree with me on that. I'm thinking it's a very subjective assessment that we are all trying to make. Now, if he knew that there was no threat to his life, and the bodyguard could opt to fire at the person whom he was supposed to guard, his life is in not danger, maybe misplaced, maybe right idealism, he may have murdered that Prime Minister a little earlier than what he did. Well, if that be so, there is a place for capital sentence on deterrence. Very planned murders, if you know that definitely you will be caught and the same will be, retribution will take place, your life will also be taken away. There could be, I am only trying to theorize, there could be a possibility of deterrence. So I think Bachchan Singh has concluded it as a place. It is a penological purpose. It continues. I think I don't know how many of you have read the dissenting judgment by Justice Bhagavati. In that, there is one interesting reference. In the erstwhile princely state of Travancore, they gave up they abolished the death sentence. And then the Justice Bhagavati says, but the murders did not increase during that period of time, and there was no death sentence. Yes, one relevant data maybe, but not authentic enough for me to accept meekly that death sentence has no deterrent place at all. And therefore, I choose in our interaction today to proceed on the assumption that death sentence serves the purpose of deterrence to a certain extent. Well, there are two schools of thought on that. I subscribe to the other. Real deterrence lies not in the severity of punishment, but in the promptness and the certainty of the punishment. Well, more people can be deterred from committing a crime by the thought that they will be caught and punished immediately than the thought that they may be hanged in some uncertain future date. So my point today is, what is most important is not the severity of the punishment. I take it, I accept I don't want anyone to join issue with me on that. Death sentence may have a place, an additional deterrence. I accept that. But that additional deterrence will also be squandered if it is not timely. If it is not, importance of the punishment is in the promptness of the punishment and the certainty of the punishment. These are aspects which we must have give greater emphasis than the severity of punishment. I say this because the purpose of a criminal justice system, because I always find as soon as there is some heinous crime committed somewhere, the so-called the public opinion, the so-called bookish academicians all come with the theory that the punishment should be increased. When the Nirbhaya case came, they said make the rape punishable with death, little realizing that the severity does not really, our grassroots experience will tell you, the severity is not the thing for deterrence. It is promptness and certainty of punishment. See, expeditiousness and the certainty of punishment, which would be far more deterrent than any other. In that view of the matter, there is always a scope for discussion, scope for debate as to whether there is any additional deterrence because of the existence of a death sentence. But for the moment, for today's discussion, I think we must readily accept that it exists, and we'll proceed from there. But that doesn't take away the importance of what I want to tell you. The importance of promptness and certainty of punishment, even a death sentence. When you ultimately send a person to the gallows 20 years after the commission of the crime, it is so hopelessly non-productive because the promptness part of it is not attended to. And therefore, it is important, even in a case where we have the death sentence, that the consequence of the crime, well, in a country wedded to rule of law, in a system wedded to rule of law, there must inevitably be a distance between the event, that is the crime, and the punishment. The shorter the distances, the better for the system. But you can never avoid the distance. There must be the distance between crime and punishment. In any society wedded to rule of law, where you speak of the great virtues of reasonable opportunity, evidence which you can rebut, evidence which you can adduce to prove your innocence, hearing an appeal to cure the human errors involved. And therefore, I'm not saying that there can be event and the crime and the punishment quickly following the response immediately following the crime. There must be a distance. Given that distance, given that inevitable distance between crime and punishment, if that distance gets longer and longer, I believe the system discredits itself. And therefore, I feel that there is a good case to revisit the Bachan Singh doctrine. And that takes me to the next important question. What is the Bachan Singh doctrine? Where do you find the real law? Of course, death sentence has been held to be constitutional. That is one part. But the real crux lies perhaps in paragraph 209, the last two sentences. I'm not going to read it to you. We must all have known it. It ultimately says the respect for life in our constitutional existence must tell us that there must be an adherence not to deprive life if possible, save, this is the crucial line that I want to, save in the rarest of rare cases, where the alternative option is unquestionably foreclosed. According to me, this is the real dictum. You can resort to the death sentence only when the case comes within certain category of cases. They call it the rarest of rare cases. It is my humble opinion that the rarest of rare case is just a label given. The test to identify the rarest of rare case is given in the next portion, where the lesser option is unquestionably foreclosed. Well, we have been in after Bachan Singh, we have been engaged in a great endeavor to find out what is the rarest of rare case. I believe the litmus test to find out the rarest of rare cases, where the lesser option is unquestionably foreclosed. That should give you the right accent, emphasis to find out that case in which a death sentence is to be imposed. We have always been trying to find out the rarest of rare case. And generally what happens is when you go to the Supreme Court, you will find, oh, 5 people have been murdered. I don't think that is the test. I didn't find out the rarest of rare case at all. We commit a mistake in doing that. The real test, the acid test, the litmus test is the lesser option unquestionably foreclosed. That is the test. Well, and therefore, any ideal death penalty law, true to Bachan Singh doctrine, must always try to find out, is the lesser option unquestionably foreclosed in a given situation? Well, in our over-involvement to identify the rarest of rare case, at times we have erred and we have lost the crucial test to identify that class of cases where death sentence is to be imposed. Where, I repeat, the lesser, the Bachan Singh called, the alternative option is unquestionably foreclosed. Well, the attempt must then be to find out which is the case in which that lesser or the alternative option. I want you to remember this. When Bachan Singh was laid down, there was only one alternative option. What is that? Either death sentence or life sentence. There was no other option. A death sentence and a life sentence, as we all know, that was the only option that was available. And therefore, Bachan Singh used the word where the lesser option is unquestionably foreclosed. Well, it's interesting. It was perhaps a bad commentary on the system that the majority judgment by 4 judges, that was delivered in 1980. I just looked at the dates also. 9/5/1980, the majority judgment was rendered. The minority judgment, which is reserved, comes long later on 16/8/1982. It's interesting. Most of us have not seen the importance of that. See, what is a plural toil? Justice Krishna uses the word plural toil when a bench considers an issue. What is the plural toil? If the majority has not seen the minority judgment, how is the plural toil a plural toil at all? Well, if I don't have the opportunity to read the minority judgment and the majority renders its judgment, how can it be? How can that be said to be a proper judgment? It's my feeling that Indian system has not mastered the art of writing a plural judgment. Excuse me for saying this. I have many reasons. It is enough if you read some of the celebrated judgments to find out the inadequacy of rendering a plural judgment in our system. So what I said was, the majority judgment did not have the advantage of the minority judgment, or going through the minority judgment. That itself is a reason which I would think that we need to revisit Bachan Singh now. One of the reasons that I would strongly advocate for revisiting Bachan Singh is the reasons given in the minority judgment were not considered by the majority. The manner in which the minority wanted to put it has not been seen by them at all. Now, 40 years have passed by. The dignity of life, the concept of dignity of life changes very often. And therefore, there is one more reason why we must revisit the Bachan Singh doctrine again now. It's time to revisit. 4 decades, 1980, the judgment was rendered. 4 decades have passed. The society has marched forward considerably, and therefore it's time that we take time to go back and revisit Bachan Singh to find out how it deserves to be improved, modified. One more very good important reason I have. You will find that thereafter came the Swami Shraddhananda decision. You know Swami Shraddhananda decision. I don't have to give you the citation. The 3-judge bench, beautiful judgment according to me. A judgment in which Justice Aftabala said the resort to the death penalty must be made less frequent. For that, the learned judges, 3-judge bench led by Justice Aftabalam finds out a method. And he says, the normal life sentence today in the Indian context is imprisonment for 14 years.
Audio.
Again, audio. So we were on Swami Shraddhananda decision. Now, the Swami Shraddhananda decision is very, very important decision in the matter of a death penalty in this country. It has broken ice and carried the battle for abolition much, much further. The war against abolition, it was a great battle won by the abolitionists. When Swami Shraddhananda said, the dictum I may summarize and say, the hiatus between an ordinary life sentence which can be commuted after 14 years and a real intended life sentence where a person must continue in imprisonment till life ebbs out of him, that hiatus can be made use of to create different shades of a life sentence, and so that we can make less frequent the imposition of a death sentence. Well, the hiatus between an ordinary life sentence and a real life sentence which says until life ebbs out of you, you will be in imprisonment, that hiatus can be made use of by a court to impose a punishment so that chapter 32, the chapter E, 32E will not apply, commutation, etc., would not be possible for that sort of a sentence. And therefore, Swami Shraddhananda said that we can increase the alternative options. I told you 209 of Bachan Singh said when the alternative option is unquestionably foreclosed. Came our Swami Shraddhananda, you find it is not the only alternative option. Now options are created. Multiple options are created by the judgment in Swami Shraddhananda. And therefore, today you can have different shades of life sentences. An ordinary life sentence where chapter 32E would be available to be considered for commutation, remission, etc. after a period of 14 years served under 433A. The court, while imposing the sentence, looking at the gravity of the offense, nature of the crime, nature of the offender, can also say no chapter 32E for a period of X number of years. You can also say no chapter 32E remission, commutation, etc. for the entire rest of the life also. Well, please read Swami Shraddhananda in tune with 209 of the Bachan Singh judgment. And today you will have to read Bachan Singh judgment as when the life cannot be taken except in rare cases where it belongs to the category of rarest of rare cases, where the Bachan Singh said the alternative option is unquestionably foreclosed. Today, after Swami Shraddhananda, you have to read the judgment as when the alternative options are unquestionably foreclosed. Right? Once you do that, the law changes considerably. See, the alternative options are increased. And you also say one of the reasons which which weighed in favor of a capital sentence is that this person with this propensity to commit the crime cannot be sent back to society. If there is a law which can be imposed by a punishment which can be imposed by courts, permitting courts to impose a punishment which says you shall not go out of prison for the rest of your lives, society is adequately protected against the culpable propensities of this man, offender. So one important reason to impose the death sentence, liquidation of a criminal with such propensities, is also served by imposing that worst form of life sentence contemplated under Swami Sadananda. And therefore, I think it deserves, the Bachan Singh doctrine deserves reconsideration now. It deserves to be revisited to accommodate within it the multiple options of life sentences created by Swami Sadananda. I know some of us are very, very opposed to the idea of a Swami Sadananda variety of a life sentence. I know, but a lot of people think that the executive's power cannot be usurped by the judiciary by resorting to this sort of an interpretation. That is where I think we have to think aloud on the other possibilities that are available. What should be the ideal death penalty law in India? We have to take into account all these circumstances. Just one more and I go to my more important point. You will find a decision in Bariyar. You know that decision, most of you must have read. I can give you the citation, the Bariyar. In Bariyar, a bench said that the track record of the Indian judiciary, I'm not using the exact words, high courts and the Supreme Court included, in identifying the rarest of rare case as that our track record has not been enviable. There has been unequal application of the rarest of rare doctrine. It depended upon the judges. It depended upon the mental makeup of the judges. There was no uniform standards. There was no thread which was identifiable from the various decisions. You must go through a Bariyar in which the learned judges from paragraphs 104 to 112 deal with all sorts of cases where our attempt to identify the rarest of rare case has been faulty, has not been just, has not been fair. And therefore, it is said, that takes us to a larger question. If my sentence would depend upon the mental makeup of the judge and not on objective criteria, please understand that is the gravest violation of Article 14. At least, of course, human errors here and there is always there. You try to perfect that. But if the death sentence, I know in my time we knew that. I don't know how many of you know that. There were times when we said Supreme Court had hanging benches and life benches. Your case goes before X bench, you are bound to get a life sentence. If your case would go before another bench, which they call the very, very euphemistically called the hanging benches, that you are bound to lose your life. What does it head? Where are we heading? It might turn out that the most valuable of all my possessions, my life, would depend upon the mental makeup, parenchyma of the judges that constitute the bench, and not on objective criteria which are identifiable in advance. That's a very sad situation. That cannot be the law. I don't think as men and women belonging to votaries of rule of law, you will ever permit that. Of all the arguments against death sentence, nothing impresses me more than the argument that decision may depend upon the mental attitude, the background, the upbringing of the judges concerned, individual judges. Well, my life cannot depend upon that. Life of an individual cannot depend upon the mental makeup of the judge at all. There must be objective criteria. If by my misfortune it goes before a hanging bench, I lose my life. If by my good fortune my case goes before a life bench, I get my life back. That cannot be the law. That certainly cannot be the law. How do we eliminate this? See, I know some of the jurisprudences have tried giving marks for each circumstance, adding up all the marks and finally deciding what should be the sentence. It has been proved to be most ineffective. Myriad are the fact situations available, arising in each case, that it is impossible for human nature to specify all the circumstances and adopt a standard which is uniformly applicable to all. Which means justice administered through the human agency may have errors creeping in. It may be unavoidable. But how do you minimize that? Under what circumstance, what are the circumstances that you can rely upon, you can press into service to make sure this human variation or the makeup of the judge does not affect the final choice between life and death? An ideal death penalty law for India, I would think, must actively address itself to this primary concern. The decision should not depend on the mental makeup of the judges. It must have more objective criteria. Well, you have seen all that. Machi Singh made a very, very disastrous attempt to identify which are the aggravating circumstances, which are, and ultimately said these are all only illustrative, not final. Because every case may not fit into the pigeonholes created by Machi Singh, or for that matter, the most ingenuous of human minds may try, but they may not be able to do that. Which means human discretion will have a place there. Is that a good enough reason to abolish the death sentence? It's a question of opinion. Maybe the Supreme Court on a later date will consider that. But as of today, it has been held to be constitutional, and therefore we have to evolve methods by which this human element does not really affect the decision materially. To eliminate would be impossible. I will accept that. My experience as a lawyer and as a judge would tell me that however much you might try, you may not be able to eliminate subjectivity altogether from judging. The whole life of the system, the whole life of the judges is geared to eliminate subjectivity in decision making. You try, a good judge keeps on trying that. Eliminate my subjectivity from any decision that I'm taking. Forget about death sentence also. That also included. That's the core issue there. But in every decision, you try to eliminate your subjectivity from the decision making. But you're not always successful. You're not always successful. But at least in the matter of choice between life and death, this should not creep in. How do you do that? Well, I would think that human ingenuity can certainly find out methods, and it's not impossible for us to find out an ideal death penalty law which can try to eliminate. Say, those students of calculus will tell us it may tend to zero, it will never be zero. It can only tend to zero. Human subjectivity of the judges can be eliminated to such a minimal extent that it may tend to zero, though ideally it should be zero. We may not be able to achieve zero. How do we do that? I think a combination of several factors, change of law, change of attitudes, all will have to be pressed in order to evolve an ideal death penalty law for India. And that is where when the experience that I have in the system, when I talk, I believe first thing is that the prosecution must be called upon to demand at the first instance itself whether they are pressing for a death sentence in a case or not. Today what happens is, after the trial is over, the conviction is over, it is then that you open the book to see what the punishment ought to be. Death sentence is such a category of sentence that the prosecution must even initially make up its mind as to whether they are demanding a death sentence in a given case. That is very important. And that decision must be left to a group or a committee of persons, an entity made up of individuals, which should include, if I may, by way of illustration, the investigating officer, certainly, the primary man, the prosecutor concerned, the Director General of Prosecution, the Director General of Police, maybe the Home Secretary. They have to decide beforehand whether in a given case we want to demand that the court must impose a death sentence. you know sufficiently early whether you are pressing for a death sentence. In a 173 report which you file, you will have to say that the prosecution wants to press for a death sentence in this case. Now, if you have that, I take you to the next part. Now, the death sentence, you know, those acquainted with the trial procedures would know, the judge pronounces the death sentence, the verdict of guilty, and the next question is, what have you got to say about sentence? And invariably, I have found the first answer that I get is, sir, I'm not guilty, which betrays his ignorance of the scope of the proceedings. Right? It completely betrays his ignorance about the scope of the proceedings after the verdict of guilt. And therefore, it is important that in a case which demands, and I believe people must apply their mind very carefully to this question, and when they make a decision beforehand, whether they want to demand a death sentence in a given case. And if they want it, it must go through the mechanism of a committee of an entity, of a very high entity, very highly placed officials, and they must, in the 173 report with the police officer files, that we have decided to demand a death sentence in a case like this. Well, if that be so, added to that is the requirement that the investigator must investigate into all aspects having a bearing on the sentence. Today, after I pronounce that you are guilty, when I ask for what have you got to say about the sentence, though in law he is entitled to use all evidence, our accused, our prosecutors, our defense counsel, no one has so far really appreciated the width of the contours of that inquiry. Not even a probation report is available in the file. You know that. Not even a probation report is available in the file when the judge enters upon the latter final responsibility of identifying the sentence. But I believe if a prosecution demands that a death sentence must be imposed, the prosecution must collect all material having a bearing on the question of sentence and place it in a seal cover, probation report, family report, everything, antecedents, everything must be inquired into, and that must be placed in a seal cover and given to the court, which will be opened, as in the case of probation report which you collect in advance, which will be opened only after the verdict of guilty is pronounced, so that the contents will not influence in the adjudication of guilt. Well, that is, according to me, is very important because it is significantly absent. Most of the courts today choose between life and death as a sentence on very inadequate, very, very unsatisfactory, very, very puerile material. If you have a law which says you must demand death sentence sufficiently early, and if you have a law which says that you must have collected all information relating to the sentence and you must share it with the court, maybe in a seal cover if you want, and it will be opened only after the verdict of guilt or innocence is pronounced, only thereafter it will be opened, that will be a meaningful inquiry into the options that are available on sentence. Well, two things therefore are very important for me. One, the prosecution must be obliged to make a demand in the 173 report in a murder, in a death sentence case, whether they are demanding, whether in their assessment this is a case, it must be left to the highest levels, highest level should also be involved, and so that it can be ensured that only in a proper case such a demand will be made. Now, along with this, I want also to say our IPC will have to be amended. Swami Sadananda punishment of a life sentence without remission for an entire life or for a certain period of life must be made legally valid. Section 53 of the Indian Penal Code has got to be amended to say life sentence A, life sentence ordinary, B, life sentence with a rider, that chapter 32E regarding remission, commutation, etc. will not apply for a specified number of years or for the entire rest of life, as the judge may order. Well, the constitutional powers are there. No, that's a different matter. The statutory power under section 32E, chapter 32E, can be altogether excluded by imposing a life sentence permitted by law. Today you have only Swami Shraddhananda or later Sriharan, the constitutional decision. Only those two decisions are available now. And those two, Sri.R. very interestingly tells, it is not a power which the session judge has, the trial court has. It is only the constitutional court that has the power to do it. I don't understand. If the session judge is entitled to impose any punishment authorized by law, and this is one of the punishments authorized by law, I don't know how a session judge can be deprived of this power to invoke that option. Well, be that as it may. I said two things now. Amendment 53, now, licensing has not been given statutory recognition so far. 350, what is the section? 354.3.
354.3.
354.3, Ramkumar. It says that the reasons must be shown.
Special reason.
Well,
Special reason.
Right, that is what I'm saying. The special reasons will have to be shown when you opt to impose not a life sentence, but a death sentence. Right? The special reasons. Now, Swami Shraddhananda has to be incorporated into 353.4 to say that special reasons as to why alternative options, I underline options, are foreclosed must be given. So special reasons to me is a little vague. The special reasons can be made clear. Statutory recognition of the licensing principle can be incorporated into the subclause to say, subsection to say that special reasons as to why any other alternative sentence is unquestionably foreclosed must be mentioned in 353.4. If that is said, you will find then another safety, another safeguard against subjectivity. You know what you have to say. You have to say, see, today, sorry to say this, I have also been a judge. It depends upon the ability of the judge to use adjectives. Gory, dastardly. You use all sorts of very good words, and then you sometimes miss the wood for the trees. You really do not apply your mind to the question as to how the alternative option is unquestionably foreclosed in a given case. On a question between life and death, I believe this should not happen. There should not be. I come to the next part. You know, the time at our disposal is short, so I'll just mention the areas where I think an ideal death penalty law could be framed. Today, a session judge is permitted to impose any sentence authorized by law, which includes a death sentence. Right? Look at it. Your life may depend upon the individual discretion of one judge. One judge comparatively lower in the rung of hierarchy, and he would impose the death sentence on you. From that day, you will have to live with the Damocles sword hanging over you, subject to confirmation by the High Court, of course, subject to appeal before the Supreme Court. But the time gap between imposition of a sentence by a single session judge to ultimate confirmation and execution is really, really, really long. We have got to shorten this. We have got to ensure that my life does not depend upon the individual, shall I call it discretion, shall I call it predilections, shall I call the subjectivity of one relatively inexperienced judge of the lower rank. Well, should a session judge have these powers? As a High Court judge, as a principal session judge, I know the dangers involved in this. I don't want to elaborate. I know the dangers involved in this individual discretion of one person to impose a death sentence, whereupon the man lives under the shadow of the death sentence until he is executed or his sentence is reduced. So, individual discretion of a comparatively junior judge, a judge who is comparatively lower in the rung in the hierarchy, can that be permitted to prevail at least for a period till the confirmation comes? Well, there I have very serious reservations. I think the ideal Indian death penalty law should not give the discretion to the judge to impose a death sentence. Individual single judge when it goes to the High Court, only two persons can confirm. When it goes to the Supreme Court, now after RF, three judges to sit and decide. And now in the lowest rung, you are relegating the discretion to an individual may I call it, inexperienced, lower in the rung judge. Can that be permitted? Cannot that be altered? Cannot that be modified and improved? Well, that is where I would say the death penalty law may have to undergo a change. And the individual session judge, after trial pronouncing conviction, if he feels that anything other than the death sentence is okay, he can impose that. But if he should think that all the alternative options are unquestionably foreclosed, he has got to refer it to the High Court, not for confirmation, but for imposition of the sentence, imposition of an appropriate sentence. This in one shot, you are able to fire two birds. One, the long period after imposition of the death sentence can be humanely altered. Second, the discretion of an individual judge in the lower rung can also be avoided. Well, and therefore, a sentence of death can be imposed only by a bench or the High Court. Section 28(2) of the CRPC, which says session judge may impose any sentence, including a death sentence subject to confirmation, may perhaps have to be amended to say that the death sentence, the session judge can impose any sentence authorized by law except a death sentence, and if he feels that all the other options are unquestionably foreclosed, then he must refer the matter to the High Court for imposition of a death sentence, giving appropriate sentence, giving all his reasons as to why he is feeling so. We cannot avoid discretions in the matter of imposition of death sentence. I am suggesting a method by which you can avoid subjectivity and make sure not the individual discretions of a judge, but the collective wisdom of a body of a three-judge bench, which of more experience, higher in the strata, can be made use of to take that decision. So once conviction is made by the trial judge, the individual session judge, I'm not saying that every trial should go to the, in any case that happens, that what happens is that judge, if he finds that all the other options, alternative options to a death sentence are unquestionably foreclosed, must, along with the report, send it to the higher court saying that I don't think I am entitled to impose the appropriate sentence in view of these circumstances. You please impose the appropriate sentence. Well, then in the place of the discretion of an individual judge of the lower rung in the hierarchy, you will have three judges of the High Court acting together to exercise the discretion. Well, one more thing I have to say. My experience tells me that on a vital aspect like this, all the three judges must be asked to write separate judgments on their own. I'm not distrusting any judge. I'm not trying to underplay the importance of discussion, but I would like it to be made clear that I agree principle will have to go. It's my experience, unfortunately, that when I agree, as much of effort and enterprise are not put into the decisions. At least on the question of life and death, I want each judge to write a judgment of his own on the question of sentence. And if only all three of them would agree, will a death sentence be imposed? You know why? Licensing which you have accepted tells us when the alternative options are unquestionably foreclosed. If of the three judges, at least one of them would feel that the other option is not foreclosed, I would feel that it is not unquestionably foreclosed. A unanimous decision of all the three judges in favor of a death sentence must, by separate judgments, must be insisted before a death sentence is imposed. All three of them will have to write separate judgments on this question using their faculties. Only if they agree on the imposition of a death sentence can the death sentence be imposed on him. In Nalini case, you know that Justice Thomas wanted to introduce this principle which said If at least one of the robed men, very senior robed men would feel that the lesser option or options is not unquestionably foreclosed, if he feels it is not foreclosed, it is not unquestionably foreclosed in accordance with the dictum in Bachan Singh. And therefore, if only there is unanimity among the judges in their separate judgments on the question of sentence, can the sentence be imposed? Can the death sentence be imposed? Otherwise, a lesser sentence may have to be imposed appropriately. Well, I think next one is going to create a lot of ripples, I know. Such a sentence of death imposed by a high court on reference to it by the trial judge on the question of sentence must also be subject to confirmation by a 3-judge bench of the Supreme Court. I'm talking about life and death, the most precious of all divine possessions. And therefore, even if the time of the court is taken, I would think their time is usefully spent. Even otherwise, invariably, every case comes to the Supreme Court and a death sentence, either pro bono, either legal aid, it comes. But I'm saying here it must be insisted that that must also be, so that all the 3 judges of the Supreme Court to confirm the sentence of the High Court must again unanimously opine that death sentence is appropriate, all the alternative options are unquestionably foreclosed. Well, if that be, that's only then that a sentence of death can be imposed and be executed, imposed by the High Court, confirmed by the Supreme Court by 3 judgments, unanimous separate judgments written by them, then only it can be done. I am trying to, in the ideal death penalty law that I have in mind, I may not today be able to, given the polity. No, I should mention to you that also. A court or a law cannot have more civilizational refinement than the polity. If our ministers distribute sweets when a criminal in custody is shot on the road, if our ministers, public men applaud the officers who have shot a person in custody dead on the theory that he tried to escape, if you are applauding them, if you are encouraging them, it's too much for me today to argue that the death penalty should be abolished. It will not take place. Now, even if it takes place, what will happen is the ugly head of private vengeance will be raised. The polity will not tolerate a refinement which they do not accept. Law cannot have a refinement more in quality than what the polity would tolerate, not accept, would tolerate. And if that be so, I think today it is too early for us to consider abolition of death sentence altogether. But resort to that must be made less and less frequent, more and more infrequent. And therefore, the methods which the ideal the death penalty law must have all these ingredients written into it. We are engaged in a very sublime attempt to ensure that there is no arbitrariness, there is no subjectivity in legal deprivation of life, and for which I think this experiment is worth it. You're not wasting the time of the court, you are profitably employing the time of the court. The Commercial Courts Act says High Court benches can be commercial courts. If that can be, Supreme High Court benches can be. If that can be, I'm certain that imposition of the death sentence can also be left exclusively to a bench of the High Court. Well, so much fine-tuning is to be done. This bench must be reasonably certain. It must take identical views in all cases, and therefore there must be a death sentence bench for the High Court, 1 or 2, depending upon the number of cases that you have to handle, so that there is some uniformity and the individual variations do not fluctuate so much. Now, even if one of the 3 benches, the permanent bench, death sentence bench, had to go, one can be inducted, though that those 2 will continue. I am engaged in a very sublime attempt to avoid subjectivity and personal predilections in the deprivation of life in this country. And therefore, I am emboldened to suggest that these attempts must be introduced. These attempts must be brought in. Well, if that is there, now one more thing. When the matter is pending, today you find there is a matter before the Supreme Court is confirmed, and then the matter goes back to the High Court saying that the president is not considered a death penalty. And then it drags on and on and on and on. Well, if you have a law that once the matter, once the High Court imposes the death sentence, the matter goes for confirmation, all other proceedings relating to that death sentence can be filed only before that bench of the Supreme Court. A lot of time, waste of time in the subordinate courts, the lesser courts can be avoided. The interest of expedition will be served best by having that, and so not interim orders at every stage, one High Court directing the president to consider and the other asking them to furnish all documents. Like that, it drags on and on and on. All such proceedings can be only before the Supreme Court when it reaches the final confirmation of the death sentence. You avoid considerable length of wastage of time on that also. I would even think, it's a little too much for me to suggest that the warrant of death must be executed by the Registrar General of the Supreme Court after the mercy petition period is over. After the mercy petition is decided, it doesn't go back to the first court again to decide. So many, the Nirbhaya experience, so many experiences would tell you, it just drags on and on and on with one petition or the other. If the warrant of death after confirmation is to be issued by the Supreme Court after the disposal of the mercy petition by the president, and then all these multiplicity of proceedings can perhaps be avoided, and we can ensure that expeditious justice. See, okay, if you have a reason, if you think that death sentence will serve the purpose of deterrence, it is equally important that that death sentence is also expeditiously imposed, so that deterrence is served best. And not, see, many of the death sentences, if you analyze, death sentences have been imposed after 10 years, 20 years, 50, it has been imposed. That's why in the famous, the case it was said that I've already served 2 life sentences ordinary. And after that you're going to hang me. Well, this delay ought to be avoided. And that is where I think an ideal death sentence law must realistically take note of the bottlenecks, the loopholes that we have. And we must be able to devise a death penalty law which will meet the requirements of our time, meet the dictum in Basant also, and be just, fair, and equitable. Well, I would think that one more thing that I omitted to mention was, as soon as the prosecution demands a death sentence in a case, it must straight away be posted for trial. As soon as the session judge submits a proposal to the High Court to impose a death sentence, to impose an appropriate sentence, that the court must take its hands off all other work and must dispose it off. Similarly, when it comes to the Supreme Court, this idea of death penalty, death sentence cases pending before the High Court, the Supreme Court, and again dragging on is so noxious, so disturbing. It should not happen at all. If you find a death sentence is to be imposed, it has got to be imposed expeditiously, reducing the trauma of the individual and serving the cause of an ideal death sentence. Well, I know I've been controversial in many of the things that I've said, but I think my experience tells me that we've got to evolve a death penalty law which will serve the interest, the Basant doctrine as it is. When you visit it after say 10 or 20 years, what will happen if the death penalty will be abolished altogether, I do not know. But maybe at the moment today's conditions, I think we will have to evolve a death penalty law which is more appropriate. I would also think that it is not in the case of session judge trials alone. Even death penalty under the Armed Forces Tribunals Act must also, according to me, get the approval of the Supreme Court ultimately, if we have value for life, if we are as much votaries of the right to life doctrine, we must make sure that no death sentence in this country is carried out without it passing through the High Court of the Supreme. Thank you very much. I think I have taken more than the allotted time. Thank you.
Thank you very much, sir. Given the current scenario of police and investigating agencies, the quality, a very bold 4-stage formula, next best to abolition of capital punishment. Can I have the comments of Justice Somayajulu first, because he may have to leave by 5 o'clock.
Sir, thank you so much, sir. It was a pleasure listening to you. But are we not depriving the accused of one tier of appeal by directly asking the High Court to impose the punishment, sir? Now at least the accused has 2 tiers of appeal, one before the division bench, then before the Supreme Court for review of the whether penalty. Are we not depriving him of a right?
Very good. Your question is very, very, very relevant. I've thought about that too. But you are getting the matter decided by the very same authorities. In our anxiety to eliminate wastage of time, and in the interest of certainty and the interest of eliminating subjectivity, we are resorting to this method where all the 3 consider. Now, I have thought about it. Very, very good question. Because after knowing that it is a sentence of death, he has a right of appeal. But what I said, the Supreme Court confirms the death sentence, there is no further appeal. Yes. But the same question is being considered at the session judge level. You are given the opportunity to persuade the session judge to feel that death sentence is not the only option. You are given the opportunity to satisfy the 3-judge bench, each judge of the High Court to be satisfied that death sentence need not be imposed in this case. You are getting a further opportunity before the Supreme Court, before each judge to persuade him to say that this sentence of death should not be confirmed. I believe, and in the 7 persons, I calculated 7 or even I would say, even the executive in the first one that I said, 173 report, will have to apply their mind and say it's a death sentence case. Now the session judge will have to do that. 3 judges of the High Court individually will have to agree to that. 3 judges of the Supreme Court will have to do that. I think the technical absence of the right of appeal after coming to know that the death sentence has been imposed can be ignored in a situation like this. I've thought of it. Good question. That's what a practicing lawyer. I think you're still a practicing lawyer. Your mind is alert. Yes. You're still a practicing lawyer.
Yes, it has not gone out of my system yet, sir.
Yeah, I understand.
Thank you, sir. Thank you, sir.
I've been a judge for 25 years. Still, I'm not able to kill it. Kill that instinct. So I know how difficult it will be for you.
Old habits die hard, sir.
Yes.
Now it has been revived also, so you will be going back to the original thinking.
Thank you, Somayajulu sir. Over to you, Ramkumar sir.
Excellent presentation, Justice Bhatt. I'm sorry, Brother Basant. But I have some difference of opinion regarding certain areas.
Tell me.
You have a point in asking the question. Is the purpose of deterrence really served by merely having death sentence on the statute book, unless it is sure and certain? Good point. Very good question. But then, it is the lenient prison rules which are responsible for premature release. Even before that, Supreme Court has held in ever so many decisions.
Maru Ram, for example, isn't it?
Maru Ram, even before that, Satpal, etc. Yeah. That imprisonment for life means till the entire remainder of the biological life of the convict. That is life sentence. It is because of the prison rules that they come out earlier. So the real villain is the prison rules, not the law, especially the interpreted law. Then Swami Shraddhananda's case is, according to me, is a blatant encroachment into the executive dominion. Even after Swami Shraddhananda, do we find murders and rapes on the decrease? I don't think. Then, according to me, it is time for us to revisit the benchmark of rarest of the rare. What is there in the rarest of the rare? After all, 354.3 only says when you are awarding death sentence, give special reasons. How can special reasons be equated to rarest of the rare? I don't think. I think that that benchmark should go. And all that needed is only special reasons. Then, whether it is the ipse dixit or idiosyncrasy of the judge concerned, that always operates. This is not in every judge. It always operates.
Reduce that, minimize that is what I said.
It always operates. It invariably operates. And we, not only on the criminal side, we know in the High Court, some judges anti-tenant judges, pro-landlord judges. There have been judges. There are judges who have that. Even one of the finest judges, he had such prejudices. I don't mention his name. He was one of the finest judges. He was one of the finest judges. But he too had prejudices, likes and dislikes. So that always operates according to me. Then a demand for canvassing death penalty in all 173 reports will become an empty ritual without applying their mind. Police, you know the police, they will invariably come with a request for death penalty invariably in every case. Then the discretion, I cannot agree that the discretion to pass death sentence should not be invested with the sessions judge, who can be said to be inexperienced. First of all, how can we say that judges of the higher courts are more learned and more law knowing, knowing and more experienced than judges of the lower strata?
Why do you appeal to them?
In fact, why
do you appeal to them? There's a
not to the person, not to the persons.
The court. That's why I said all three of them must write separate judgments. Eliminate subjectivity to the extent possible. I know.
I still remember Justice Paripurnan used to say there are more district judges who are more learned and more experienced than many of us.
That's all scratching your back, sir.
Anyway, I heard such comments also. And from the feedback I got, I heard that more impartial justice is given at the lower levels than at the higher levels. I don't mention about any court, but I have heard feedbacks from lawyer community, from client community, that we get more impartial justice at the lower level than from the higher level. That also cannot be forgotten. Then delay. What about the clemency jurisdiction of the governor, president, etc.? The delay, even if the judicial process is done expeditiously, you can't direct the president of India to decide a particular case within a particular time frame. After he is a constitutional functionary. Then clemency jurisdiction, they may take their own time. We have very bad what should I say, experience also with presidents, etc. Yes. And that is one suggestion of yours is very good, that all the three judges should give separate judgments, but with a rider. There should not be any previous circulation. There should not be any previous circulation.
That is implied, Ramkumar. Otherwise, I would be saying.
How do you say that? How can you say that? It will happen. It will happen. Basant, please circulate your judgment. Let me go through that. I will say. I may say.
You won't say that. I won't say that. I'm very certain. We would never say that. When the law says that it must be separately pronounced, I don't think any judge of the High Court or the Supreme Court is saying, "Brother, please show me your." No, it should not happen. If you don't have that much of trust in the judiciary, it will not work.
Reading your judgment, I can give a similar judgment with totally different wording.
That's not what my law expects. That's all that I say, and therefore I'll expect judges to follow that.
Yes. No guarantee that it will be circulated.
Nothing in human affairs is guaranteed, Ramkumar. You can only try.
Exactly.
You only venture. The success
ideal situations are never to be achieved. Ideal situations are always ideal. Those goals we will never achieve.
That doesn't militate against the struggle for ideal.
All right, that is so. Then I remember Justice Krishna Iyer saying years ago that the normal period of gestation for a case in the Supreme Court is 10 years, those days. If that is so, what about the confirmation? Confirmation will come after 10 years.
You heard me say that too, isn't it? You heard me say that too.
And the confirmation
The
court,
court must take its hands off all the other cases, all your commercial courts, all the commercial courts appeal. There must be benches to deal with it exclusively.
Brother, don't we have rules to say that criminal cases should receive priority in the sessions courts? Don't we have rules? Are they followed?
They will come in the act, sir. What I suggest, they will come in the act. Imposition of death penalty act. That is what I have in mind.
And confirmation courts can also acquit, not merely confirm.
You can. Yes. There's no doubt about it.
It will be virtually a re-hearing of the appeal.
It has to be. It has to be. There's no doubt about it.
Then what priority will it receive at the hands of the judges?
I can only think that law must ensure that it gets priority. Whether it actually gets.
All are ideal goals. Ideal goals. Whether we will achieve that is. These are all my. Otherwise, it's an excellent presentation. Beautiful presentation. Well done.
Yeah, Ramkumar sir, somebody has to, walk the untrodden path, and we'll have to have some ideal set so that at least we should aspire for that, right?
Yes. I only raised the
practical realities. Absolutely, sir. Absolutely. No,
Ramkumar, when I coined the topic also, I said an ideal death penalty law for India. I'm conscious of the fact that it is ideal. Our success lies in working it. Many of the things which you said, I've thought about it. The police may invariably ask for death sentence in every case. You must have heard me say that you must involve the investigator, the prosecutor who are directly involved, as also the DGP, the Director General of Police, the AG also. You get a higher level of consideration. That's all that I can insist. That's all. I see. I cannot start with an assumption that no one will do a professional job. They must be doing a professional job, and if that is then the professional pride will be hurt if they endorse all death sentences. They must send a report for asking for death sentence in all cases. It doesn't. You can see in the court arguments how many cases are death sentences pressed these days. Just go back to the session judge's chair and tell me how many cases are death sentences pressed now? No, it's not. It's not. And therefore, all that can be, this death sentence must get priority and must get listed immediately. That's what I thought.
And what about the benchmark, rarest of the rare cases? All that the law requires is only special reasons.
No, Ramkumar, you heard me say that must be amended to incorporate the Bachan Singh doctrine and say that the court must give special reasons as to why all other alternative sentences are unquestionably foreclosed. You are transplanting Bachan Singh into the special reason, the 354(3). That's what I said. Now it's only Bachan Singh. There's no statutory backing. That's why I said 324(3) will be amended to incorporate that requirement of Bachan Singh into this provision. To say that how all alternative options are unquestionably foreclosed.
Let us anyway, worth experimenting. Worth experimenting, definitely.
No, Ramkumar, I'm sure as a session judge, as a high court judge, these things must have tormented you, isn't it? These things must have troubled you. Now I get back to play my third innings in the Supreme Court. I'm now dealing with the death penalty appeal after review, this, that, everything. We are dealing with the review of a very bad event which took place years back. It torments you. It asks you, what are you doing, Mr. Basant? What are you? Or you are performing an empty task. Are you doing anything meaningful, worthwhile? It disturbs you. It is the disturbance that gives me ideas to come before you with this.
Delay, how far we will be able to cut short the delay is a question to be practically looked into. Delay will be there, definitely. Because how far we will be able to cut short the delay.
Ramkumar, I would want Chief Justices with the guts to say all death sentence cases will be distributed among 3 judge benches, and until that is over, we are not going to touch any other matter. See, you must have the guts to do that. See,
that can be the rule, but not the practice.
No, practice is, you have an amended law, I think it will be followed. You have the bar to insist that you must do that. The bar is there to keep you on the right track, not only the statute, What is stated in the statute must be insisted to be followed by the bar also. See, I very often feel, Ramkumar, I very often feel the bar is not playing its role rightly. I think bar has a corrective dimension in its existence. Bar must have a corrective dimension. A judge goes wrong, you must have the guts to stand up and say, oh, judge, this is not correct, you are going wrong. Now, in sitting in the Supreme Court also, I find very, very, very senior judges, when the judge misbehaves to a junior lawyer, he does not react. Whereas my adored senior, Bhaskar and I, in a magistrate's court, would have stood up and said, this is not the way. In a sessions court, he would have said, this is not the way to treat a junior. I don't find that sort of assertive independence in the bar at the highest levels today. It's very unfortunate. You know, it's not as though don't blame only the bench. The bar is also equally at fault. I, as a member of the bar, am also equally at fault. See, the dictation is not a dictatorial act. I keep repeating this. Many of us think that dictation is a very dictatorial act. You have to comply with the law. And therefore, when you do not comply with the law, it is for the bar to tell the judge that, sir, you are going wrong. You should not do this.
Yes.
Well, the vibrant bar must also play its really effective role. Now, you can see the consequences of absence of such assertion by the bar.
Yes. Anyway, wonderful idea. Definitely. No, I'm serious. I'm serious. But you can't presume that the judges at the lower level are more, at the higher level are more learned, more knowing. That presumption we cannot.
Kumar, I would only say they are more experienced.
How can we say that?
No, why? 1 minute. Why is a session judge's decision made appealable before a high court? You are questioning fundamentals.
Krishna said,
Ramkumar is questioning. See, so many. Sorry.
The judgment, Krishna once said, the judgment of the Supreme Court is final because there is no further appeal provided.
I agree with you completely. Why is finality given to it? Why is finality given to it?
We have given a finality, that's all.
No, why is finality given to it? Tell me. Because the system accepts that the human errors can be corrected at a higher level, by a higher court, by courts which are more experienced.
Not always. Not always. Not all.
All right, Ram Kumar. See, what happens is, today, I became a sessions judge. Tomorrow, I'm dealing with a murder case, a death penalty case. Now, if you have a special death sentence bench, the Chief Justice can nominate persons with some experience and then only do it. So it's not impossible. I know there could be difficulties, but it's not impossible.
Why not we have special courts at the sessions level? Death sentence judges or only murder cases.
See, you and I know very well that individual discretion of one individual compared to collective wisdom of three is always better.
Collective bargaining can also be there.
It's not. Let's not assume bad things will happen. Let's not assume bad things will happen, and it can happen with the one judge also here. If that can happen with three, it can easily happen with one. Right? We are trying to avoid needless delay and promoting certainty. That is the only attempt is that. And to leave my life to the discretion of one relatively lower run, relatively inexperienced judge would be much more chaotic than leaving it to the collective wisdom of three more experienced judges at higher rank. That's all that I say. No, it's not between an individual judge in the High Court and the Munsif, district judge. Sometimes the Munsif, Chakrakannan was first decided by a Munsif, right? And it was only ultimately accepted by the Privy Council. The idea came only from a small little Munsif. And therefore, I'm not talking about wisdom or, acumen. I'm not talking about that. I'm talking about practical ways to avoid subjectivity.
Let us see.
All the session judges are not Ramkumars. That also. I see. It's embarrassing for me to give details. You know those details. How people impose death sentences. The first three cases, you go to a district, people impose death sentences. You have seen it. You have seen it, isn't it? And therefore, don't see between individuals can be bad here or there or anywhere. That's not the question. That's not the question.
Listen, sir, if I can just, before we go to Ramashan, sir, one simple doubt, sir.
Please.
Sir, you advocated that the sessions judge should stop short of passing the final judgment if he feels that all other options are unquestionably foreclosed. And refer the matter to the High Court.
No, what I said was he must pronounce judgment on conviction or acquittal.
Okay.
And then proceed to the next stage where you
That
decide the
stage is-
punishment. Only that. Otherwise, it will be a general appeal. As Ramkumar rightly pointed out, when it goes for imposition of a imposition of a sentence also, the validity of the conviction will still be open before that court.
Absolutely, sir. Absolutely. That's good.
So
Ramashan, sir.
you don't really lose the right of appeal, as Somayadulu said. You don't lose the right of appeal, but your right against the sentence alone would be hampered. There he is right. There what he said is right. Because now, after the session judge imposes or the High Court judge confirms, High Court bench confirms, you have a right of appeal before the Supreme Court.
Correct, sir.
Which may not be there. But so far as conviction is concerned, all the three courts will consider the validity of the conviction. On that, there is no problem.
Absolutely. Ramashan, sir.
Anyway, as usual, Basant has got a novel idea of introducing new thoughts on criminal jurisprudence. As a judge also, as a used to advocate on so many things. See here, one thing is that the idea is good, but normally when it comes to the division bench and full court, as a High Court judge, you may be knowing that we try to have a consensus. If there is any difference of opinion between us, we will say, you write your judgment, I will write my judgment. That is normally happens. I don't think that each judge will be circulating. Without circulating, suppose something happens, who will decide which is the which point, which aspect is right, and ultimately conclusion judgment will be written by whom. So normally when it, I'll finish my thing. So what normally happens is we will have a consensus as to where the difference of opinion arises, as where we will have to differ, etc. We can able to convince each other that this is a point where we will have to go this way or that way. And normally we will be entrusting one person. Normally the senior or the senior will entrust the junior to write the leading judgment, and that will be done. And thereafter they will discuss, and then ultimately if there is any difference is there, they will write their opinion on that, and that will also be circulated. That is how I think that I feel that is what is happening in the High Court and the Supreme Court now.
Right.
As regards the other is concerned, unless the law is amended regarding the right of appeal, I don't think that once the conviction is there, and thereafter the only for the question of referring the question of sentence, the higher sentence alone, because not even the life, higher sentence alone need to be to the High Court by a 3-bench or 2-bench judge.
Confirmation proceeding, confirmation proceeding today it's happening.
No, confirmation what happens is, because there is a conviction and sentence, the accused is also filing an appeal against the conviction and also the sentence imposed, and the High Court, they are deciding on the confirmation matter. They are not deciding on the question of validity of the conviction, but they are only deciding on the question of confirmation, whether it will have to be confirmed or to be returned. Suppose if there is no conviction, that no appeal is provided against the conviction, where will you agitate that?
No, Ramushan, there must be conviction. I told
unless conviction is no, I am not that. See, as Ramkumar has said, in the right of appeal has been provided not against the conviction. It is against the sentence. It is against the sentence. Only after the sentence is over, the judgment is complete. So now, because the law, as the law now stands, that is only the appeal will be lying against the sentence. When you are challenging the sentence, you are also challenging the conviction portion also. Ultimately, the higher court will be consider whether the conviction itself is proper, and if his conviction is not proper, a conviction is proper, what is the sentence about it is proper or not. So there are two ways of thinking about those things. That is how the appellate court decides. And one. Secondly, this also again goes because the right of appeal against the Supreme Court, they are also dealing with the death is first time death is being confirmed by the High Court. Death is provided by the High Court. So probably even then, if it is not confirmed, there also the Supreme Court also only go to the question as per the law now stands, unless it is amended that right of appeal also provide against the conviction.
Right, sir. No, obviously, that must be done.
No, that must be not. I do not know whether if that be the case, we will have to provide a provision for filing a right of appeal to the accused also when it has been referred to the High Court for the purpose of deciding the question as to whether what is the proper sentence to be awarded. Then both can be simultaneously heard by the High Court. Then they will come to a conclusion, the conviction is proper. Thereafter, what is the sentence to be then?
Absolutely.
Probably the Supreme Court also may go into the question whether that is proper or not.
You are absolutely right. You are absolutely right.
Otherwise, the question will be, they will be only considering the question of sentence. Supreme Court also goes, this confirmation is required or not required, then it is closed. So
and
other
sword of Damocles is definitely going to hang.
Reappreciation evidence, as in the case of filing a regular appeal on the conviction and sentence.
Are the confirmation proceedings in the High Court receiving any urgency, any priority? No priority in the High Court.
I had an occasion because I was sitting in another court, not dealing with the criminal court, but civil matters, miscellaneous matters, in a division bench. One reference came, the death penalty came to us, stating that some inconvenience was made by the judge who was sitting in the criminal appeal matter, division bench. Then my judge who was along with me was telling, no, it is a new case, why should I? I said that he is in jail. So you will have to give priority for a criminal case where the death sentence itself is under question now, whether you have to confirm or not to confirm. Then we heard it. So that things upon, everything depends upon how you treat the case.
It seldom receives any
urgency.
One interruption. When I was heading the criminal division bench, I asked him to place before me all the confirmation cases, death sentence confirmation cases. And I found totally the ones that are available were about 6 to 10 at various points. Then I said, we will finish off these matters first before we go to any other matter.
All judges are not
which is the matter which is ready, take it up, the next week get the next one ready, finish off all matters. Then how many death sentence references are there in the Kerala High Court?
Very less. As far as
so if we want, we can finish it. There's nothing that is impossible.
No, that depends. No, that is what I said. That depends upon the judge who sits or the bench.
Well, that is why I wanted to say, not the rules, not the Chief Justice allotment. Law must provide that when such an appeal is pending, the court will hold its hands and finish off that appeal first. That matter first.
Even how many custody cases are being heard by the, because they say life is there, no bail is normally granted. According to me, it is a custody case. You will have to treat this as a custody case and priority must be given to those
cases. They don't receive priority.
More than death cases.
And all judges are not justice persons.
A death case is not a custody case alone. It borders on the deprivation of the most fundamental of all gifts of God or nature, taking away your life. And therefore, all judges must ask for all the death references to be taken up first and finished. That's all that I expect. And I want law to provide for it. Imposition of death sentences act is what I want, what I'm contemplating.
Brother, our registry very often say that so many cases are pending, because in the other cases there may be the records may not be ready. Therefore, they don't treat it as pending, not pending, as pending cases.
The rules oblige the High Court judge to forward it immediately in confirmation proceedings. If that is not done, I just say a call for explanation from the Sessions Court why this has not come. Next day records come. It all depends. If you want it, you can get it.
No, not only that, one more thing I say, that even as a session judge, you may be knowing, as a random session judge, and also where the central prisons are there, you are heading the committee in this prison regarding deciding about the pre-release of the convicts. Then when you sit there, your analytical thing is, even if you convict the case as a session judge, you have a different attitude as how these will have to be considered for the purpose of whether it's a fit case for pre-release or not release. Premature release is required or not required. So you sit there in a different position and analyze it in a different position. Even you can, if you analyze it from there, probably your own judgment, sometimes after 10 or 15 years, you feel that is maybe wrong.
Parameters differ.
Parameters may differ. So that depends upon the way in which things are going on. So today, because even the Supreme Court, after a long time, death sentence was set aside only on the ground that the clemency petition was pending for more than years. There was a long delay in disposing, and they revisited and converted into life sentence.
I told you, I am training my guns even on that situation. No, I'm training my guns even on that situation.
Now, what is the authority for the Supreme Court to come that such a way, because a sentence has been confirmed to the Supreme Court, thereafter coming different positions.
I've been in the Supreme Court for long enough to ask you to read 142.
See, Rajiv Gandhi assassination, they confirmed the death sentence. And
Sir,
what did they do
what I
ultimately?
believe, sir, is a radical change in the outlook, unlearn and relearn new things, and maybe we'll get an academician's viewpoint also. We have Professor Rose Verghese here, who is the former Vice Chancellor of National University of Advanced Legal Studies, Cochin, and presently the Director Academics of Ramaiah College of Law, Bangalore. Over to you, ma'am.
Your Lordships, I'm extremely happy to be here today because while I was Vice Chancellor, I tried with Justice Thottathil Radhakrishnan as chairman to initiate a debate on the need to revisit the IPC and in the context of death penalty again. I agree with a lot of things with, which Justice Basant has said today, though I have one reservation, I'll come to it. One thing is sure, that certainty is any day more important than severity of punishment. Now, for any crime, you will see words like it's a horrendous crime, it's a cold-blooded murder, it's a gruesome murder, and therefore it calls for death penalty. But we know that, see, we all know that way back even in 76 in Padman versus State of Georgia, the US Supreme Court had said that we should end death penalty. It's too harsh and cruel. But all of us know now that our Supreme Court has consistently held that death penalty is not unconstitutional. Justice Basant, do I understand that you agree that death penalty should stay, or do you think it should be, we should think even of abolishing? I'll go to that later. I'll go to that later. But we know Jagmohan Singh 1973, Rajendra Prasad in 79, Bachan Singh in 1980, Machi Singh, which tried to give guidelines to these so-called rarest of rare cases in 83. All these cases, the Supreme Court of India has consistently held that it is not unconstitutional, not unconstitutional. But going to rarest of rare, again, the biggest problem with our criminal justice system as far as criminal cases are concerned is the fact there is disparity and inconsistency in judgments. Even in the matter of death penalty, in spite of Bachan Singh and some principles laid down in Machi Singh, there is disparity. I remember in Kehar Singh, the question arose, is it because the Prime Minister of India is murdered that this is being considered as the rarest of rare case? And the court categorically stated, the courts, they said it is not because the Prime Minister of India is murdered, but because the person in whom she had reposed confidence turned around and killed him. So that gives us one guideline. Does it mean that when, well, that takes us to that particular guideline, that in such cases, it is the rarest of rare. So the entire problem is resting around this issue of disparity and inconsistencies in judgment. So the best way to maintain consistency is to have a system in place. I hope in that amendment, because we were discussing this in the meeting which I initiated with Justice Thottathil Radhakrishnan, to look into amendments in the IPC as a whole, 1860 drafted code. But unfortunately, fortunately, he has gone as Chief Justice to Calcutta, and I came away. My 4-year tenure was over, so I could not continue this. Though I spoke to the NLU Delhi VC and Registrar, come on, let us form a committee to look into IPC. Now, sir, I totally agree with one point. The best way to avoid inconsistencies or disparities in judgment is to have one bench. That I really am so happy with that suggestion, that even the Supreme Court should have a bench exclusively to deal with death sentence cases. Then, sir, about your point about the sessions judge just pronouncing if it is guilt or no guilt, conviction or acquittal, and then pass it on. My only problem is that the High Court judge would want to know the view of the sessions judge who has gone through the entire trial. We know that the appeal stage, a lot of evidence is not taken, trial is not in detail, held in detail. So it is a sessions judge who has gone through the entire trial, the examination chief, the cross-examination, everything. And then the arguments. I think the High Court judge would want his view, whether he's competent, and if incompetent, the Sessions Court should also have a bench, not just one Sessions judge when it comes to death penalty cases, so that there will be consistency. Justice Cardoso is so right in his judicial process book, where he says that definitely the philosophy of a judge will reflect in his judgment. So there is a lot of scope for, what do you call it, subjectivity. And therefore, even sir, I'm very happy with your suggestion, Justice Basant, about 3 judges deciding a death penalty case and coming with individual judgments. They will apply their mind to the case. And if there's no unanimity, then I agree with your statement that then that statement that means there is another alternative option. If not, the 3 of them would have said the same thing. But still, it's very difficult to still decide what is rarest of rare, because see, in Ediganama justice, the High Court pronounced death penalty. Justice Krishna very, very categorically stated. He said, of course, I agree, it's a horrendous murder. He also used the expression horrendous, killing, cold-blooded murder of even the tender 2 children, not only the lady. But Justice Krishna said, we have to look at the circumstance which led to made the woman. She was not a born criminal. What led to criminality? So that is his view. But you would see Justice Krishna with justice-oriented judge. But you might find another judge, Justice A.S. Anand's judgment. I've read Dr. A.S. Anand. Sometimes he takes the other extreme view. So it depends on judges. Therefore, to maintain a consistency right from Sessions Court onward, one court should decide death penalty cases. Again, in appeal in the High Court, there should be a bench to decide death penalty cases. And finally, in the Supreme Court. And High Court and Supreme Court, I agree totally with that point of what Justice Basant said, that the three should have a unanimous view. But I share Justice Ramkumar's view that you can't totally ignore the final decision of the Sessions judge. See, he has gone through the entire trial, but if he's not allowed to voice his opinion, okay, we don't allow him, but the High Court is sure to ask him, please tell us after all this, what do you think about it? That's the only concern I have. Sorry, I've taken more time than necessary, but I wanted to send. Yeah, it's okay. Yeah, section 235, clause 2 of the CRPC, giving an opportunity to be heard on the question of sentence. There's so much of disparity even in that matter. We know that Tarlok Singh's case, Santa Singh, Alauddin Mian's case, Juman Khan's case, all these cases dealt with section 235-2, giving an opportunity to be heard on the question of sentence. There's so much of disparity even in that. Do you wait for 2 days? Do you pronounce the judgment, the sentence after 1 week? And all. So the whole problem today with the criminal justice system, one, the fact that after a rape, after 10, 20 years, the girl is told he is acquitted because the prosecution failed to prove beyond all reasonable doubt. Absurd. And secondly, the fact that the inconsistencies and disparities have to be addressed. We cannot be, like the legal fraternity cannot just be passive to this, which has just been happening for many years. Thank you. Sorry for taking more time.
Thank you, Rose ma'am. Basant sir, any comments on that?
Not really, because yes, human justice, we try to achieve consistency. At times it is difficult. You said judgments vary and things like that. That is why perhaps I said, see, we don't have computers to decide. Different persons may view it differently. Eliminate subjectivity is the mantra that we must pursue. Eliminate subjectivity. Now, in spite of that, sometimes, as Ramkumar said, some of the best judges also have been victims of personal prejudices. It happens. I'm not saying it will not happen. It should not be there, but it also happens. That is why we have tiers of appeal. Why do you think there's a tier of appeal? Given one appeal is a right, natural justice right, because that is the anxiety to eliminate human errors. Ordinary people may find it difficult to understand, but it's not a commentary on the judge if his decision is varied by a superior court. That's not far from that. When you say consistency must be there, that doesn't take away the right, power, the jurisdiction of a superior court to take a different view. And therefore, if you say consistency ought to be there, yes, generally yes. Eliminate subjectivity is the watchword. That also I am completely in agreement. But then how do you do it is the problem. That is one way of saying you're doing that is have a plural bench. Plural bench and insist on each one writing a judgment as I have suggested now.
So regarding the view of the sessions judge, Professor Rose made a comment on that.
No, Shyam, perhaps I did not make myself very clear. What I said was, after entering the conviction, the session judge will have to consider the sentence and he will have to decide whether any other sentence, any other lesser options would be sufficient. If he thinks that it is not sufficient, he reports to the superior court that I think my options are not sufficient. I don't have a power to impose a death sentence, and therefore my options are not sufficient, and therefore you decide. So it is not taking away anything from the session judge. Session judge will still have to consider the entire facts. He will have to come to a conclusion whether guilt or innocence is established. He will also have to apply his mind and give reasons as to why he thinks that he cannot impose a sentence. Adequate sentence cannot be imposed by him. He needs that also. And
the very fact of reference itself says that what his view is.
So in the scheme of things that I have in mind, I don't think his input, his perception is not ignored at all.
So on the question of sentence, he loses one appeal.
Yes, that is what Swami Adulu asked me at the first instance. I agreed. I accepted. I accepted completely. But the same is being considered by 3 judges. Now 7 judges, as I told you, and therefore there's no room for lamenting over a technical loss of a right of appeal. Loss of a technical right of appeal, because 7 persons are individually considering your matter.
Okay. Sir, we have a couple of questions. We can just rush through that if you permit, sir.
Okay.
Himanshu Agarwal, please put your question.
Good evening, sir. My name is Himanshu Agarwal. I work at the National Law University, Delhi, and I've had the privilege of briefing you on a couple of matters involving the death penalty at the Supreme Court. Sir, you spoke about the penological purposes of sentencing, and you focused on deterrence as one of the most important reasons why the death penalty should remain. I was wanting to invite your thoughts on another penological purpose, that of reformation and rehabilitation. Because Bachan Singh, in its para 206, talks about the need for evidence-based determination of ruling out the probability of reformation and rehabilitation. And subsequent judgments, Bariyar, for example, say that only in cases where the penological purpose of reformation is not met, that the death penalty can be imposed. So when we talk of an ideal system of death penalty, how will such a system come to a conclusion that in a given particular case there is no probability of reformation or rehabilitation? What kind of materials and what processes should we follow to be able to eliminate this possibility and only then impose death? Thank you.
Himanshu, you see, what I said was, if a death sentence should be imposed, it is only the purpose of deterrence to serve. If you are choosing to impose a death sentence, the only purpose it would serve is not reformation, is not reparation, but it is only deterrence. Right? That's what I meant. See, before you come to the conclusion that a deterrent sentence of death ought to be considered, you have already crossed the line of thinking that reformation can happen. Well, classic case I've seen a mother when she is accused of unchaste behavior by her husband, throwing the child into the well. That's a case where reformation is there. That's a case where the court comes to a conclusion that the deterrent sentence of death is not required. To deter mothers from killing their children in this country, it is not necessary to impose a death sentence. A reformative process can be accepted. That is what it says. All that I meant was, if you choose to impose a death sentence, it serves no purpose other than the purpose of deterrence. You understood? Right.
So, but on the question of what kind of material or evidence should a judge consider before he reaches the step of deterrence? So the prior step on. Yes.
All right. I come to it. You heard me say that the post-conviction hearings in this country is becoming very, very empty. As Madam Rose also said, 235, 2 hearings are becoming very, very empty. See, shells without any substance, any life inside. That's what is happening. And that is why, if you have listened to me carefully, I had said in a 173.8 report, if the prosecution is asking for a death sentence, they must furnish all the relevant materials on the question of sentence. Well, that would include material which would show whether reformation is possible or not. Primary burden must be on the prosecution to place before court all material warranting a death sentence. The accused can supplement. He can add his own evidence at that stage, 235 stage. That's a different matter. But the primary burden must be on the prosecution to place all the relevant material, whatever materials are there. The background that he has gone through, the traumatic life that he has gone through, the life of crime into which he was born, all those would be materials having a perception, having a relevance on the point of view of the accused. All that can be placed before the court. And that burden must be on the prosecution to do that. That's why I said, in a case where you are wanting to demand a death sentence, you must be prepared with all those materials, which will be kept in a seal cover. After conviction, it will be given over to the court. It will be opened by the court, and the court will come to a conclusion. Right?
Thank you, sir.
Sir, we have a question by Kamaraju Balakrishna. Please, sir, unmute yourself and put the question. You'll have to unmute yourself, sir.
Sir, I unmuted myself.
Yeah, sure.
Sir, I heard your lectures in Supreme Court Bar Association. The Friday lectures, I regularly hear your lectures, sir. That is on section 4 and section 112. And triple talaq lectures, they are very excellent. Now coming to this question, sir. Sir, our law shall follow one of the theories, be it deterrent, retributive or reformative. Instead, each one is following one theory. That's why there is a lot of confusion also. See, the sessions judge, in fact, he should be kind and he must follow reformative one. Whereas he is very strict, he is passing death sentence. Now, when it goes to mercy petition, the president says that he would pardon them. So instead, it must be in reverse manner, wherein in the lower court. Hello?
Yes, you can continue.
Sir, hear me?
I can hear you. I can hear you.
Yeah, sir. So another thing is, sir, there must be speedy justice. There shall not be hasty justice. Nowadays, the police are causing encounters. All of a sudden, Disha murder, it also made lot of uproar in Telangana area, wherein at a toll gate, some people had caused some mischief and some crimes were committed and they were killed mercilessly. So when such a things are just given go by, there is no trial and nothing would happen. Even when in the matters where the things are done in a spur of a moment, those things are seen as the rarest of the rare things. Now, another thing is, as far as judges are concerned, courts as regularly we practice here, we also find that there is a lot of vacuum and the magnanimity that is required at the the lowest level or threshold, that is missing, sir. That is also part of as far as the Supreme Court is concerned, the matter when reaching Supreme Court, by that time people are getting exhausted. The money is most important. The money had become most important, and justice cannot be done to the poor person. these are the things, sir, which I thought that I shall bring it to your notice, as you are also practicing in Supreme Court. Majority people are approaching you as you have been very benign to them. Thank you, sir.
Okay, thank you, thank you.
Sir, another question that has been, yes, sir. You want to say something on that?
No, nothing. He has only said
Okay. Sir, we have Advocate Suresh P. He has put a question on the chat. If I could, Suresh is there? Okay, I'll just read that question, sir. Legal Service Authority engages comparatively junior lawyers in Section 302 IPC matters to conduct the custody cases. Your comments on that?
They should not. I have no doubt. The legal aid services would become empty, meaningless, and without substance if you don't engage competent lawyers. So when you say a person looks up to the Legal Service Authority, he may not get the best of brains, I can understand that. But at least an experienced lawyer, competent to handle, must be engaged.
There are
decisions. No doubt about it.
There are decisions also there.
There are rules also, there are decisions
I think
also.
Minimum 10-year practice or something like that there.
In the Supreme Court, for example, a death sentence case, a senior counsel has to be engaged. A senior counsel has to be engaged in a death sentence case. So it has become the rule now. Therefore, I don't know which legal service authority is not engaging good counsel. You will have to. Maybe if he asks for the #1 lawyer, he may not get it. But
no, even cases I had an occasion to see that even if the panel lawyer doesn't have a senior counsel, I used to ask some persons who are sitting there who are having criminal practice.
Yeah, that should be there.
Assist the court for the purpose of taking as a pro bono case. Yeah. And they normally used to accept.
Yeah.
Yes, sir. Suman Pandey, you can unmute and put your question. You have posted one. Suman Pandey, if you are there. So what is posted is recent case in the Jessica Lal case, accused Manu Sharma released now, though he was convicted for life imprisonment.
Yeah, what is that? It's a 433 provision. It's definitely, I don't know the particular facts. So long as the court has not imposed a life sentence of the Swami Sadananda variety, the commutation can be considered after 14 years. And if the court has imposed a life sentence of the variety contemplated in the Swami Sadananda, after that period it can be considered. That is what must definitely have happened.
So one last question, that is from Preeti Pratishuddhi Dash. Please, Preeti, unmute. Yeah, please.
So good evening, sir.
Good evening,
I'm a researcher. I work with Project 39A at National Law University in Delhi.
I see.
And my question, sir, is regarding the validity of deterrence as a penological purpose, especially given that Bachchan Singh, in its rarest of rare framework, tries to promote individualized sentencing. And I wanted to hear what you think about how deterrence fits into this scheme of individualized sentencing, and whether using an individual to send a message to a society is consistent with the idea of individualized sentencing.
Well, very good. A good question. Because I want you to understand that that while deterrence, I think I said that while I started, deterrence is the purpose which any system of the dispensation of criminal justice should try to, right? That should try to ensure the right to life of the others in the society, right? Why? It may take a little time, I'll take it and tell you. See, why do I become part of the state? It's a theory of barter. I surrender a lot of my rights. I give a lot of taxes to the government. What do I expect in return? There are two things that I want. See, non-negotiable two things I want. What is one? One is protect me against external aggression. Second is protect me against internal disturbances, which I call a crime. Now, this is why state is constituted. I want state not to leave it to me to prevent crimes against me. I want the state to prevent crimes against me. When I step out of my house in the morning, when my children step out, when my grandchildren step out, I want them all to come in one piece without affected by crime, right? And therefore, the burden is on the state to prevent crime. That is why I often use the expression: a crime-free society is the beautiful destination of any system of administration of criminal justice, right? That is one way of looking at it. And therefore, I want the state to see that I am protected. You can use whatever method you want in accordance with the refined civilizational acceptance, and deterring a person committing a crime is one method. If you can change him into a good man, very good. Let that be. But I don't want people to be tempted to commit such a crime against me or other innocent persons. And therefore, deterrence has a role to play in the criminal justice administration. Second, you have a very, very rosy picture of the right to life. Right? I also have my right to life. And what is my right to life? Right to life is the right to live without being affected by crime, without being affected by the fear of crime. And I look up to the state to give me that protection. I want a life free from fear of crime, free from afflicted by crime. And therefore, look at it on the fundamental concept of constitutional state, the matter theory, this, that, they've got to protect me. Look at the more sublime idea of a right to life, you have got to protect me. So I don't know what method you adopt, you have got to see that I'm protected. And therefore, if to protect innocent citizens from being afflicted by crime, you want to deter others from doing that, you have to do that. I expect the state to do that. I have no doubt about it. I want the state to do that. Administer individual-based justice, I have no quarrel. If you can transform him into a good citizen, do it. But let it be very clear that he has to meet the consequences of what he has to do. You know, the great Gandhian, the Christian equation, crime plus punishment is equal to innocence. In convicting a criminal, I am holding him by the hands and allowing him to walk through the conduit of punishment to reach the shores of innocence. I am not acting against him. I am helping him to reach the shores of innocence by taking him through the conduit of punishment. So do not be under the impression all punishments are bad.
Right.
The sin plus atonement becomes innocence. Right? Crime plus punishment takes you to the zone of innocence. In convicting a criminal and asking him to undergo the punishment, I am allowing him to walk from the realm of crime to the zone of innocence. And therefore, imposing a punishment is no crime. It is good. It is good for the society. It is good for him too. He also gets the satisfaction that I committed an indiscretion. I went through the punishment. I am now innocent. And therefore, many of our bookish academicians do have a feeling that all punishments are bad. I do not subscribe to that view at all. Punishments are also good. But death sentence may not be punishment at all. In the sense, from the perception of the individual, from the perception of society, yes, because it deters others. But from his perception, it is not punishment in the real sense. And therefore, I would like a death sentence to be avoided if possible. Not that it should be altogether abolished. No, I can't agree.
Okay. Thank you, sir. Thank you, sir.
Sir, last two questions. One from Neema Noor and one from Nitin. Neema, please.
Hi, good evening, sir.
Good evening, Noor.
Hi, sir. So actually, one of the most conflicting thought that I have ever had is regarding the Herbert Packer's, crime control model and due process model. So if you've come across that theory.
Yeah.
Yeah. So whenever, so what would you say, you relate penology, which model would be best suited, would, the crime control model or the due process model, because we follow due process model. And, sometimes I find like crime control model, if it was that which was adapted, wouldn't you feel a death penalty would be best suiting crime control model where investigation was so tactful, so proper instead of due process model? So what do you say, sir, about that?
My view, personal viewers, crime control model and due process model are not conflicting models.
Okay.
They have to be harmonized. In the interest of society, it has to be harmonized. Now, see, where there is no way to deter a person from committing a crime, probably the extreme penalty of death sentence may also have to be imposed on him. It depends on the facts of each case. I don't think in the Indian scenario anyone would be justified today in demanding. I told you that already. In demanding that the death sentence be abolished altogether today, because society is not prepared to accept it. Some of us high-grown liberals are willing to accept that. That is why, as I told you, when somebody in custody is shot, people are celebrating it. A system of law, a judge, the laws cannot try to be more refined than what the society would tolerate, not accept. I don't want them to accept, but they must tolerate. Otherwise, the ugly head of personal vengeance will be raised. And therefore, please do not be under the impression that that due process model and the crime control model are conflict with each other. They do not. In the ideal sense, they do not conflict at all. Right.
Thank you, sir. Thank you so much.
Nitin, please unmute and put the question.
Yeah. Thank you, Shyam. Namaskar, sir. I hope I am audible. So my question is actually about the execution. Sir, now when yesterday I was watching the movie Rajguru and Bhagat Singh, they have been... yeah. Hello, am I audible, sir?
You are audible. I can see you.
Sir, Rajguru, Bhagat Singh, they have been given death sentence. Those warrant was, I mean to say, it was preponed. So whether it is validly, can government prepone such warrant? I mean, is it valid? The date was preponed.
I didn't get the question. I didn't get the question correctly. Repeat that, please. I didn't get your question correctly. Please repeat that question.
Nitin, please, can you repeat the question?
Have you understood? Did you get the question, Shyam?
No. I mean, he was referring to a death sentence warrant being cancelled. I didn't get anything else.
So not that one. No, what I understood correctly is because death sentence was awarded, a date was fixed earlier, warrant was issued. But in the case of Bhagat Singh's execution, when it comes to the execution, it was preponed and executed. Whether that is illegal or not, what is the question?
I will have to look at the relevant rules at that time to finally give an answer.
The time for appeal has not been that.
And today, if you fix the execution to a particular date, you cannot perhaps prepone it without notice to him and giving opportunity for it.
Particularly when the appeal time is not over.
Yeah, appeal time over, no question. No question of a warrant being executed. But after everything is over, if a date is fixed, even then if you have to prepone, you have to give. Yes, you have heard that, which was the case in which this time is the time given for him to atone to his creator. Did you read that, Nitin? This time given, a person is told that a death warrant will be issued against him and he will be executed on so and so date. And that time has been described to be his time to mend with the creator. He is to get himself prepared to meet the creator, and therefore. Suddenly preponing it would be against all known accepted canons of criminal justice.
Correct, sir. So I think Advocate Vishwanathan has raised the hand, even though late, but still, please.
I can see his hands being raised. Yes, Vishwanathan, what can I tell you?
Sir, my question is, how this death sentence can be correlated with Article 21 of the Constitution, right to life?
Right to life is not absolute, sir. Right to life is not absolute. No one shall be deprived of life and liberty except in accordance with the law, except in accordance with the procedure established by law. Procedure established by law, if it is satisfied, it is justified. If it does not affect your fundamental rights, if it is not affecting the legislative competence, etc., it is procedure established by a valid law. A valid law which should also be reasonable law after Maneka Gandhi. And therefore, if those requirements are satisfied, 21 does not stand against a death sentence unless you take the larger view that a death sentence is invasion into the dignity of life. You know what has been canvassed so much in the Bachchan Singh case, what was canvassed and what the minority accepted also.
Okay, sir. Thank you.
So 21 doesn't conflict with it. If you can, your life can be taken away in accordance with procedure established by law. I underline law which is valid, which is reasonable, which is not capricious, and then even your life can be taken away.
Sir, I think the questions are over. So to conclude, over to you, Prem.
Well, what could I say? It was absolutely insightful, drawing the entire attention of the audience and holding them all through this full 2 hours. But just to add something, because I heard Professor Rose saying about the United States Supreme Court decision in Furman versus Georgia. See, actually, that is a 72 decision, which again that was thrown overboard in Gregg versus Georgia in 1976. Because Furman's case, that stood at an extremely different footing. That was one considering the ambit of death sentence in relation to the amendments like the 8th and 14th amendments of the US Constitution, which is not the case which we have in India. That cannot be taken even to compare the cases in India. Furman was thrown overboard in 1976 by Gregg versus Georgia, which you can see. And subsequently new laws also came in, because there was something like the 8th Amendment and the 14th Amendment, which we don't have in India like laws. And with regard to the death sentence, of course, at some point of time it may appear that it is barbaric, but you can view it through two different perspectives, because the proportion of the first degree murderers who are sentenced to the death, it is small, because it depends upon the degree of commission of the crime, I would say, because death sentence, because deterrence, as I would say, deterrence is a function not only of the punishment severity, but also it should have some kind of certainty and frequency, I would say. Anyway, it was absolutely insightful class, absolutely wonderful. Thank you so much, sir. Thank you so much.
Yes, Rose Madam, please. Yes.
Sorry. I know it's time, sorry. I was saying I don't agree with Furman versus State of Georgia, and I'll tell you why. I would like the students who intervened to go through Maruram versus Union of India, where the where the court says the triple purposes of punishment is retribution, deterrence, and rehabilitation. And we cannot have just one purpose of punishment. And it's always, the argument is for right of life to the accused. We cannot ignore what the accused has done to bomb a whole hotel and everyone. And so I'm totally against abolition of death penalty in India. I'm with the Supreme Court in its consistent stand in retaining it. And I think retribution and deterrence are purposes of punishment. I don't agree with Georgia, Furman versus State of Georgia.
No, madam, I think you have taken me on the wrong foot, because I was just saying that Furman, Georgia, that cannot be even compared in this particular thing.
I know. It was no. I was just saying, yeah. I was saying the judge there observed that it's cruel and all that, but no, I don't agree with it. That's what I'm saying. I got your point.
Observed that it was cruel. Why? Because it was against violation of the 8th and 14th Amendment of the US Constitution. That's
I know.
In India.
Yeah. No, I got your point. I'm only re-emphasizing that I'm against abolition of death penalty, and I like the students who intervene to just read Maruram versus Union of India about the triple purposes of punishment.
Nobody can say that death sentence is constitutionally unacceptable. It is constitutionally acceptable. And constitutionality has been upheld also. There were so many cases out there which we have. Thank you so much.
Thank you. Basant sir, any concluding remarks?
Yes, one. You all must read the minority judgment, which is often ignored. You know, it has held, minority judgment holds that it is not constitutional.
True.
It gives reasons for that. It was not accepted by the majority, definitely, and therefore that's not. But you will get the point of view as to why it is held to be opposed to the Constitution, constitutionally not valid. You can see that, you may disagree, but it will give students an insight into the idea. Even making use of 21, one judge has held that it is not constitutional.
Yeah. But that minority view was not read by the majority.
That's what I said. That's what I said. I have strong disagreement with the manner in which it is being. This is being pronounced. It should not happen at all.
Sir, that brings us to the end of 107th session of really it was legal empowerment through interaction lecture series. The interaction and the way in which new ideas, thoughts were accepted, resisted, or even suggestions were put. It was just wonderful. All of us are benefited. I mean, we have got new things to contemplate, deliberate, and till we meet on Friday, I'm sure that this will, we'll all put our head to that so that we'll have new thoughts regarding capital punishment and this different stages that has been suggested by Basant sir, so that some sort of certainty and some sort of articulation could be brought into the field of giving capital punishment. And thank you, sir, for this wonderful presentation and sharing with us your thoughts and ideas on this novel aspect. And we are thankful to Justice Ramkumar, Justice Ramakrishnan sir, Justice Somayadilu, Professor Rose Buage, Senior Advocate Sesharajam, and all these wonderful participants for making this a wonderful session. And we'll be meet next Friday. That is in our 108th session. We have Advocate Kirtivas Giri. He's a lawyer of advocate of High Court of Kerala. He'll be dealing with the subject competition law in India and overview. And to introduce the subject, we have Justice P.N. Ravindran, Senior Advocate of Supreme Court. Of course, he'll be introducing the subject and we'll be having concluding remarks also. So till we meet on 21st, that is coming Friday, 3:30. Please do take care, stay safe, and let us think and contemplate about the nuances of having capital punishment and how it has to go about. Thank you. Thank you very much.
Thank you.